Hello and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your CPD requirements, and at the end of the podcast we will explain how to get in touch if you wish to claim CPD points or if you have any comments or questions.
Hello and welcome to podcast number 105. We've got 3 cases. In other words, we're back to the normal format. As promised in the last podcast, I was going to say a few words, well, it's actually quite a few words, about the Uber case. But I've also got something to say about the Brogden case, which is a bonus case, and Perrott, which clarifies a point which I didn't realise needed clarifying, but there you go, we live and learn. Also, simply because I can, it's my podcast, I was going to mention a couple of concerts I went to and why I ended up listening to cover versions of Leonard Cohen's Chelsea Hotel 2 nights in a row. So, all that and more to come. As usual, please don't forget you can access the podcast via iTunes, it's on the Mayor Brown internet, it's YouTube, the Twitter feed, Nicholas Robertson at NicholasRobert11, which is also where we post out links to all the cases we have discussed. So, first up, Aslam and Farah and Uber, BV and others. As I'm sure you're all aware, there's been a significant tribunal case involving Uber. This was decided a couple of weeks ago. It was just before the last podcast, and I wanted to take some time to reflect on what is really quite a complicated case before trying to summarise it for the purpose of this podcast. The full decision runs to 40 pages or so, and the indications are that Uber is going to appeal. So bear in mind the case is continuing. I'm summarising a lengthy judgment in rather more succinct terms. The basic case was a number of Uber drivers brought claims arguing there was a failure to pay them a minimum wage and there was a failure to provide holiday for them, and there is also apparently some whistleblowing claims brought by claimants, but they didn't form part of this preliminary hearing. The preliminary hearing focused instead on the status of the individuals. Obviously, the status of the individuals is important because jurisdictionally, if they're looking to claim the right to annual paid leave, the right to national minimum wage, etc., they need to show that they are employees or workers. In practice, as I'll explain, the only way they were going to succeed was to show they were workers on the particular facts of this case. In order to explain matters, it may help just to remind people what the basis of the definition of a worker is. A worker, obviously, it's a halfway house category between an employee, someone who works under a contract of service, and someone who is self-employed and or in business on their own account. For there to be a worker relationship, there needs to be a contract under which the individual performs work personally for another party to the contract, where the individual is not carrying out a professional business on their own behalf. In other words, there needs to be a contract, there needs to be a requirement for personal service by the alleged worker, and when you look at the relationship between the alleged worker and the alleged employer is in fact not an employer, but is a customer or client of a business undertaking run by the individual. So that's the legal situation. Against that background, the factual situation is complicated. What I was going to do is to deal with the tribunal's findings on worker status before then going on to try and explain some of the ancillary issues, but by no means all of them, in relation to the national minimum wage and working time regulations. Uber in London operates through 2 separate companies. Uber BV, as the parent company, has the rights to the Uber app. It's based in Holland. Uber London Limited operates, astonishingly enough, in London. The clue's in the name. And, according to the contractual documentation agreed with the drivers, Uber London acts as agent for the drivers. Crucially, the document is very clear. Uber does not provide a taxi service for the customer. Uber London's documentation says the contract for provision of the taxi service is between the driver and the passenger. Uber seeks to position itself as simply being a technology platform facilitating taxi services. It asserts very clearly in its documentation that it does not actually provide the taxi services themselves. It was accepted by the tribunal the drivers had complete freedom to choose whether or not they wished to work at any point. However, if they were interested in receiving work, they needed to log into their Uber app and then be available to take passengers, literally at the drop of a hat. I think you have something like 10 seconds from being contacted to decide whether or not you want to take the job. Uber allocates passengers to drivers and, through the app, Uber puts the driver and the passenger into contact. The driver is not told where he or she is going until the passenger has been picked up, which I suspect is a bit like the London cab rank rule and is presumably for the same reason. They don't want drivers cherry-picking better jobs. The app offers route guidance, although it is up to the passenger which route to actually take. The driver is not allowed to charge more than the Uber recommended fare, The fare itself is paid directly to Uber BV via the app, and Uber BV then account to the driver less a 20 to 25% service charge. The booking terms when passengers log on to the app specifically state that Uber does not itself provide transportation services. All transportation, logistics, delivery and vendor services are provided by independent third-party contractors, it says. However, it was accepted that the drivers were providing a personal service. This was not one of those worker status cases where the individuals concerned can provide a substitute, either in reality or in theory. Here, drivers were interviewed and accepted in person by Uber, and so were providing a personal service. The right for them to use the Uber app was a personal right, couldn't be transferred or to anyone else, or they couldn't be substituted. So that part of the definition was never really in doubt. The claimant's case was that Uber, and in particular Uber London, were able to control the drivers sufficiently to enable them to be found to be workers. Passengers were not the customers of drivers. It was said by the claimants the passengers were the customers of Uber. As part of their case, to defend against the claimant's assertions, Uber wanted to show that drivers had more freedom than one would associate with workers. They asserted that drivers could work for whoever they wanted. They had to bear their own operating expenses. They were free to decide what sort of car they wished to drive, although that in turn would affect the categorisation applied by Uber when setting prices. And they would not be required to wear any sort of logo or uniform. Uber also claimed it was not providing driving services itself, so passengers were not its passengers. I think it's fair to say the tribunal did not like Uber one bit. As a result, the tribunal really laid into Uber on the facts, and it had great fun in comparing the case put forward to it by Uber with what it said were comments that had been made by Uber in a different context, which flatly contradicted their case to the tribunal but revealed the true situation. So, for example, in a TfL consultation response document, Uber London had written that every single person that gets into an Uber knows that our responsibility to him does not end when they get out of the car. There was a reference to Uber paying drivers' commission at one point, rather than the arrangement where it was the driver's fee, less a sum payable to Uber. There were a number of other unfortunate comments which did not fit with the contractual documentation which had been drawn up. Equally, and I emphasise this is my personal opinion, none of these comments went really as far as suggesting that Uber was operating a sham system. It was probably loose language rather than indicating any deliberate misrepresentation of the underlying facts. The Employment Tribunal honed in on the AutoCleanse case, in which the Supreme Court found that if terms did not reflect the true agreement between the parties, then the court could identify what it said was the true agreement. This is obviously very different from inventing an agreement that had never been agreed. What AutoCleanse said is that you look at the documentation, and if it doesn't reflect the true agreement, then you can determine what the true agreement was. The suggestion made by one of the judges in AutoCleanse was that if you didn't take this approach, quote, armies of lawyers would simply place substitution clauses or clauses denying any obligation to provide or accept work in employment contracts as a matter of form, even where such terms do not begin to reflect the real relationship, unquote. I'm going to come back to this point, but in essence the tribunal found, and in strong terms, that the documentation did not reflect the reality of the Uber-driver relationship. It said, quote, the organisation at its heart was running an enterprise which is to carry people in motor cars from where they are to where they want to be, but requires drivers and passengers to agree as a matter of contract that it does not provide the transportation systems. Unquote. It was, quote, unreal, unquote, to deny that Uber is in business as a supplier of transportation services. Quote, simple common sense, unquote, leads to that conclusion. It was not practical reality either. Uber in London is not a mosaic of 30,000 small businesses linked by a common platform. According to the Employment Tribunal, that is, quote, faintly ridiculous. Well, Uber, in its presentation to the tribunal, relied on several case authorities which it showed individuals in similar situations had been found to be self-employed. These included 2 taxi cases, where the taxi drivers were found not to be employees, and the well-known Stringfellows case from a few years back, where the lap dancer was found to be self-employed. The tribunal decided these cases were not sufficiently close that they had to follow them. Indeed, they said the reality was that those cases did not relate to the heart of the services that were being provided by the alleged employer. They said it was one thing for individuals to be self-employed when their activities were ancillary to the main activities of the employer, but here, providing the services was in fact core to the services being provided by Uber. Well, to me, that sounds like putting the cart before the horse, if I can continue the transportation metaphor. If Uber services were in fact the provision of technology, a technology business, providing contracts between wannabe drivers and wannabe passengers, those are the services at the heart of what is being offered by Uber. But if it's instead that it's starting from the assumption that the services are not ancillary because Uber is providing driving services, that again is deciding the outcome and then working back from there. In any event, I'm not sure that Stringfellows would necessarily agree that lap dancing was purely an ancillary activity. For the first, and I promised last time, I went on to the website for Stringfellows, first page only, and certainly their slogan for the services they provide wouldn't encourage anyone to believe that the food you can buy at Stringfellows is their primary service. My appointment with the London senior partner, Mayor Brown, to explain my search history on my office computer comes up next week. Having decided that individuals were workers, the tribunal then had to decide how to measure the working time for the purposes of establishing whether or not individuals had been deprived of the national minimum wage, the right to appropriate rest breaks, holidays, etc., etc. The tribunal decided both for the purpose of working time regs and national minimum wage, individuals were working when they were in the area where they were authorised to drive and had turned on the app, indicating that they were willing to work. This, crucially, means that time spent waiting on duty for bookings will count as working time for the purpose of national minimum wage and the working time regs themselves. Now, clearly, this case is a significant one. The tribunal has, in very strong terms, made a number of quite hostile factual findings against Uber. In essence, it says it has found the documentation carefully drafted by Uber, and which the tribunal could not say was ambiguous in any way, did not reflect the reality of the situation. Whatever one thinks of the outcome, and there are plenty of people who will be firmly of the view that workers in the gig economy require protection, and if necessary judicial creativity to achieve that protection, there is surely another side to this. Uber, for one thing, wouldn't accept that it was a member of the gig economy. It is one thing for a company or an employer to set up a business and draft documentation denying it's providing that business. That's clearly a ridiculous situation. The inclusion of a sham substitution clause, which is not there for anything other than show, in order to defeat a claim of personal service, is another clear abuse. It's surely something else entirely for an organisation to decide it only wants to offer a particular type of service to being found to be retaining workers. It's similar to a purchaser buying a business by acquiring shares because it doesn't want to do TUPE consultation if instead it did a TUPE transfer. It's entitled to do that. This tribunal also seemed to have no problem, in principle, with accepting that Uber might have set matters up so that it was not retaining drivers as workers. Of course, it didn't say how that might be achieved, and that can be our new Christmas party game. What facts would you have to change in the Uber case to change the outcome? I suspect you can believe that Uber is playing that very game right now. And that really is the major downside with this case and this approach. Uber has been found to have retained two individuals who are workers. This is based on a particular fact pattern which may, for all I know, be replicated for all its drivers in the UK. However, if Uber chooses to change some features of that, perhaps to release some of the control, will that be sufficient to change the status? You can see a situation, there's a whole series of test cases designed to establish quite how much control Uber has to give up before it can be found to be no longer contracting with workers. In terms of wider lessons, other than for anyone with interest in a key battleground in employment law at the moment, I think the lesson's clear. If a tribunal wants to defeat your very carefully drafted documentation by saying it doesn't reflect the reality of the situation, it may be very difficult to rein them back in. Equally, if you're running a business or setting a business up and you want to stay outside the clutches of, say, employment or worker status, if that is what bothers you, then you do need to be alive to the fact the tribunal may come in and say that the nature of your relationship is worker status or employment status, whatever your documentation may say. If you do require documentation to be drafted, then you need to ask yourself whether it accurately and actually reflects the reality of the situation. Individuals who are in a markedly weaker bargaining position with the employer may well find the tribunal is quicker to come to their aid, I suspect. So that's the Uber case. That's Aslam and Farah and Uber, BV and others. So, next up, Brogdon and Reed and Investec Bank. This is a Court of Appeal decision related to a claim for breach of contract, and in particular a claim for failure to pay bonuses to which the two claimants asserted they were entitled. In the end, the Court of Appeal's decision turns on a relatively narrow point, but it's still an interesting case and helpful in the vexed area of discretionary and, as we shall see, not so discretionary bonuses. The background was that the two individuals joined Investec in 2007 to set up a desk trading equity-based derivatives. There were significant guaranteed bonuses for the two of them in the first year. The idea was that they were going to set up a structured equity derivative, an SED desk, which then in practice developed into equity-based financial products for the retail investment market. The SED bond issue was extremely successful and raised a lot of money, which was then available to the bank for a fixed term, which it could use in other areas of business. So in that sense, the desk was a source of funding for the bank, and so its corresponding value to the bank was not just in terms of the desk itself and what it did, it was also that it enabled the bank to do things elsewhere. The contract said that the bonus calculation, quote, will be based on an EVA formula calculated as 40% of EVA generated by the equity derivative business in year one. That went down to 30% in the following years. The case turned on what was meant by the expression EVA. Parties agreed that EVA meant economic value added. The individuals claimed that the purpose of the bonus provisions was to give them an incentive to make the SED desk as profitable for the bank as possible and to give them a share in the economic value they created. So they said that, in order to measure that value, you had to look at how much the bank had benefited from their activities, which could be calculated in turn by reference to the cost it would have incurred if it had raised an amount equivalent to the investors' deposits if it raised that in the capital markets instead of through investors' deposits. The bank disagreed with this assertion strongly, said that it accounted for each of its business lines and activities individually for EVA in order to identify which were profitable and which were not. In the second and third years, the gap between the two different ways of calculating bonuses was bridged by agreement. The bank made available a greater sum for bonuses than it considered the individuals were entitled to, and so matters were smoothed over. However, in the fourth year of operation, the bank's method of calculation, EVA, showed the desk was operating a loss, but in the view of the individuals, they were entitled to the bonus, and so the two of them fell out, left, and sued the bank. At the trial, it was alleged by the two individuals that they'd also had an oral agreement prior to joining as to how EVA was to be calculated, but this factual contention was rejected by the judge and was not appealed. However, the High Court judge held that the bank had a discretion in relation to the way in which it assessed EVA. This led into a discussion at the High Court stage on the basis on which a bank's discretion could be challenged by an employee who was dissatisfied with the bonus. The judge held that unless it was shown the bank had acted irrationally or in bad faith, it was not possible to challenge the exercise of discretion. On that basis, the High Court decided that the bank's definition of EVA, i.e. focusing just on the desk itself, was correct and the individuals lost. They went to the Court of Appeal and again repeated the contention that the bonus was a discretionary one. They said it was irrational to calculate EVA solely by reference to internal profit and loss rather than the overall commercial benefit to the bank derived from having available for use funds raised in this way rather than through ordinary capital markets. However, Court of Appeal took a slightly different approach to the High Court. They said that the bonus was governed by a contractual formula rather than being discretionary. They pointed out that the definition of EVA meant economic value added generated by the equity derivative business. When it was taken into account that the judge had found various facts, such as, for example, at the High Court stage, the judge had found that calculations were generated automatically on an EVA basis for each business unit. There was a predetermined formula for calculating EVA. Reasonable people would, in the position of the parties, have understood the phrase to have meant the amount calculated as the EVA for the equity derivative business, using the method normally used by the bank, which had, I should add, been briefed to the individuals. So, overall, the bonus was not, in fact, discretionary. On that basis, the High Court had been right to hold that EVA meant the EVA of the desk itself. It did not have some sort of wider connotation looking at indirect benefits generated by the desk. However, the Court of Appeal said it wasn't a discretionary bonus scheme. The individuals had the right to have the EVA for the SED desk calculated in the way set out. Corresponding, the bank's obligation was limited to compliance with that formula. So, in the end, the argument put forward by the individuals, based on the bank having a discretion and failing to take into account the wider picture in an irrational manner, fell at the first hurdle. It wasn't a discretionary bonus. Clearly, one of the lessons to be learned from this is to look carefully at whether a bonus is really properly discretionary when mounting a challenge. Conversely, if you're drafting a bonus scheme, obviously it is necessary to consider whether you want the bonus to be discretionary or not. Provided there are no ancillary agreements or provisions cutting across what is put into the document, the employer has the upper hand because it's the one that drafts the contract or the bonus scheme, so it is able to provide whether it's a fixed formula or a discretionary basis and which factors are to be taken into account. So, that's the case of Brogden and Reed and Investec Bank. Final case, much shorter, Perrott and City of Cardiff. This is an EAT case, and really I've included a sort of clarification, a point which I'm surprised needed clarifying, but may indeed have needed clarifying, and so it's worth knowing. Indeed, by the time the EAT came on to hear this matter, the employer, the respondent to the appeal, said it was completely neutral on the appeal and didn't make any submissions, contrary to the terms of the appeal, put forward by the individual. Basically, the individual worked for the council starting in 2003. She was disabled. She was often absent from work on matters which weren't always disability-related, but some of them were. There were a number of reasonable adjustments considered for her work. The council's long-term absence policy was applied to her during periods of absence, and ultimately she was dismissed, because it was felt she was not going to become fit to work again in the foreseeable future. Her tribunal claim was for discrimination because of something arising in consequence of a disability, Section 15 of the Equality Act. There was a failure to comply with the duty to make reasonable adjustments and unfair dismissal. The claimant's claim both for disability discrimination and unfair dismissal failed at the tribunal stage. The EAT accepted, however, her appeal against this decision. She was relying on a provision criterion or practice, a PCP of course, which she argued put her at a substantial disadvantage because she was disabled. The Employment Tribunal had decided, however, that because the policy in question applied equally to all employees, it was an answer to a complaint to say that the policy applied equally to disabled and non-disabled staff. Accordingly, the claim was rejected. However, the EAT said that the tribunal decision was fatally flawed. Similarly, the EAT said that a suggestion by the tribunal that the unfair dismissal claim could be rejected because it was, quote, parasitic, unquote, on the claim for discrimination also had to be rejected. The way the EAT put it, quoting an earlier case, quote, if the PCP bites harder on the disabled employee, the duty to make reasonable adjustments arises, unquote. Clearly, there may or may not be particular reasonable adjustments, but the duty will nonetheless arise. Here, of course, there was a policy, a sickness-absence policy, that applied to all employees. It didn't stop it biting harder on her, and therefore there was a need to consider a reasonable adjustment to take away the disparate impact. Here, reasonable adjustments had included things like fetching materials that come out of a printer, so the claimant didn't need to walk to the printer, or providing a supervisor and reducing her workload. Overall, therefore, I think this case is really confirmation of a point which would certainly follow most advisors' view of the legal situation, that if you're considering whether or not you need to make reasonable adjustments, it's no answer to say that the particular term or condition or whatever that applies to employment applies to all people equally. If it disproportionately affects disabled people, then the duty to make reasonable adjustments arises. So that's the case of Perrott and City of Cardiff, short and sweet at the end there, but just reiterating that you're not looking at trying to find a difference of treatment, it's the difference of impact where you're looking at reasonable adjustment cases. So I said I'd say a couple of words about the two concerts I went to this week. I saw, first of all, on Monday I saw Regina Spektor at the Royal Festival Hall, and then on Tuesday Nathaniel Rateliff at Brixton. Very different concerts. She's, sitting there, grand piano, and a number of backing singers. Nathaniel Rateliff, well, as I was describing it to a couple of people we were talking to at the concert, it's Motown played by white guys. But both of them stopped the concert about halfway through and performed a really good solo version of Chelsea Hotel, which is one of my favourite Leonard Cohen songs, and as a tribute to his death. So so good, both great concerts, worth listening if you get a chance to listen to either Regina Spektor or Nathaniel Rateliff, and frankly listen to Chelsea Hotel as well. So there we go. That's enough on the cultural front. Thank you very much indeed for listening. Onwards and upwards to podcast episode number 106 in a couple of weeks' time, and I hope you all have good weekends. Cheers.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments or want to know how to claim CPD points, please email Nick at nrobertson@mayorbrown.com. Our podcasts are an overview of the cases, and how the law applies in any particular case will obviously depend on the individual circumstances. So please take legal advice if any of the matters discussed are relevant to issues you are dealing with. Thanks for listening.